Welcome to the Jurist Law Podcast.
Welcome to the Jurist Law Podcast with Kimbro Stevens and Shane Cox. I'm Matt Skye. Kimbro serves as managing attorney and Shane as chief legal counsel at Jurist Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. Kimbro, Shane, welcome.
Thank you for having us today.
Good to be here.
Yes.
All right, so why did you decide to focus your practice on estate planning matters in Arkansas?
Well, being from Arkansas might be the most obvious reason, but estate planning is important because, whether you have a big estate or a small estate, you have what you have and you want to protect it and make sure that it's protected during your lifetime and it's protected for your heirs one day. And a lot of times people don't think about planning ahead and, people don't think about, one day I may not be here. But let me say this, for anyone that's ever lived long enough and has seen family members pass away, they've always had to hear things about, well, Papa or Grandma didn't do something ahead of time and it ended in a train wreck. Or maybe a grandma went broke in a nursing home and people just don't understand that you don't have to do that. If you do a little proper estate planning, you can protect assets. So the thing about estate planning is it really is the groundwork for asset protection and protecting money over time as you get older so you don't outlive your money. And, so estate planning is kind of part and parcel what needs to happen in what we call elder law as we get older, because that is sort of the wraparound of protecting things. If you're going to protect something, you got to have a plan, and that plan involves your estate, and therefore that's where we get the word estate planning.
So then let's clarify, is estate planning just for the super wealthy?
Well, no, because like I said, most people have a house, they may have a 401k or an IRA, they may have a couple cars and a dog. Whatever. And whatever you have is still important to you, but you can lose it if you don't plan properly or you don't plan ahead. And what little you have, if you lose it, well, you can become indigent or destitute. A lot of people go broke as they get older because they haven't taken steps to try to protect things. And particularly when it comes to long-term care and expenses for that. What about lawsuits? We can protect people's estates from lawsuits, with good techniques and things. So really what we do when we're doing estate planning, it's not about how much you have, but it is about what you have and what we can do to help you protect it.
And Shane, is it ever too early to do estate planning?
It really is never too early to do estate planning because, the concept is your estate is comprised of your assets, real, personal, intellectual property, equitable, whatever it is, you own something and you have an estate. If you own something, you have an estate, right? Even if you don't own real estate, you have an estate. The plan is what is understanding your risks. So if you're an elderly person and you're already in the nursing home and you have a house and you're going to pass, because we're all going to pass away sometime, even then it's not too late. You can still do things even then. That actually wouldn't run afoul to Medicaid, by the way. But also on a more general scale, it would also allow you to transfer your assets to your beneficiaries, your loved ones, your family, even though you're in a nursing home and even though you might be about to die. So it's never too late.
And I would just add a little bit more to that, too, because, depending on how old you are, issues do change. So if you're a young couple and you have children, your issues are, well, if something happened to who's going to be guardian of our children? So that's part of estate planning. Mm-hmm. If you're younger and you think about, how are my kids and family going to live if I get killed in a car wreck? Well, that's what life insurance is for. That's about a plan. So estate planning includes all those kinds of things. And then, of course, as you get older, well, we're more concerned about protecting what you've developed over your lifetime and not going broke in a nursing home. So there's always different phases. And that's the thing about estate planning. It's a process. It's not an event. So your estate plan needs to evolve over time as you get older. So it's never too early to have a plan, and it's never too late to have a plan. But the important thing is have a plan. And whatever plan it is, it needs to meet at that time in your life the issues that you're facing.
So we know the importance of planning. What happens when we fail to do proper estate planning?
The risk that your assets while you were living that you've run into, it's going to hit you directly well, it's going to hit your loved ones or your heirs, beneficiaries directly in the face when you pass. So it could be catastrophic. If you think about someone not doing anything, not even a will, okay, and they own an asset to themselves, if they didn't at least plan for their wife, right? So in other words, think a piece of real property just fell his name and he never put it in his wife's name. Well, to get it transferred to his wife and his children, you're going to have to go to probate. That opens the door for all kinds of, creditors, the lengthy, expensive process. And then at the end of it, because he didn't take care of his wife, he didn't at least do a will, right? We really would want him to avoid probate, but because he didn't at least do a will, his wife's not even going to get the property. She'll just get a limited use. And so that puts her possibly in an adverse position versus his kids. You can, if you don't do estate planning and you have assets and you think the way they're going to go, it's probably not going to go that way. And you're going to cause serious conflict, cost, and expenses to your estate. And you're going to cause stress and a lot of problems with your family.
We brushed on it a little bit, but what are the common documents everyone should have in place?
Well, we use several documents. At different times, we might do different things depending on the age of the person, but always we recommend a will, always, because a will is kind of a catch-all document. If you have a beneficiary, let's say you have a bank account and you don't have a POD on it and you don't have a joint owner, that account's going to go to probate and you need a will to determine who's going to go, where it's going to go. Because if you don't have a will, the state has one for you. And it may be not what your wishes are. So that's the difference between dying with a will or without a will. So a will is always basic to every plan. Now, then you get into sort of optional things like, well, am I going to have a trust too? And if I have a trust, then the will need to complement that trust. And you may have multiple trusts. You may have business entities. You may have LLCs. You may have corporations. Those are also optional documents. But another very important document is a healthcare power of attorney. Now, when we think about power of attorneys, we're talking about documents that if someone has an incapacity or they can't make decisions on their own anymore, either because they've been in a car wreck and they've had a traumatic brain injury, or maybe they just are a senior who's got dementia. We want the person to be able to pick who they would choose to make decisions for them. So that's a power of attorney. That's always a key document in an estate plan. And there are power of attorneys for healthcare, and there's power of attorney for finances. And those typically tend to be separate documents, or they could be the same. In our practice, we prefer to separate them. But again, every plan is different. Every plan is tailored to meet the needs of that client. But generally speaking, the one document that we always have in every estate plan is a will, because if something isn't accounted for along the way, at least the will is there to determine not only who's going to get something, but sometimes who's not going to get something is important, and who's going to be in charge of that estate after your death. So, in a way, those are kind of the basic documents.
Does everyone need both a will and a trust? And is one ever superior to the other?
So, as he said, you're definitely going to want to get a will so that if, your everything falls apart, at least we have the elder showing his intentions on paper to show where the asset's supposed to go. Hopefully you never have to use it because you've avoided probate by something else. So that's the very least. Not everybody needs a trust per se, but I know that sounds strange because trust, if funded properly and drafted properly, will avoid probate at the very least. No matter what type of trust, right? Irrevocable, revocable, at the very least, it should avoid probate. So, but you don't have to have a trust to avoid probate. It really depends on the nature of the asset. If there's contingencies, if there's a lot of assets, if there's special needs person or possibly a special needs person in your family member that might stand to inherit assets, then you're probably going to want to trust, but you don't have to. But everybody needs a will. Yeah,
and then, of course, there's different kinds of trust, so it's not just as a will or a trust, which is better. The issue is, well, you need the right kind of trust if you're going to have one. And there's the two types that we typically have are revocable and irrevocable. But there's just like there's all kinds of cars and vehicles riding down the road, there's all kinds of trust. So the most important thing is that your trust meets the goals that you're trying to achieve. Let's make sure that you have the proper trust. And then the will is a companion document to the trust. And typically what we do with that is if we have a trust, we like that to be the primary estate planning vehicle. And then the will basically says, if I've left something out of my trust, pour that over into my trust when I pass and let the trust take care of it. And that's typically how the wills and the trusts work together.
So a lot of people, I think, are attempting DIY estate planning. What are the potential problems with that?
I see this come up where, elder puts some loved one on as a beneficiary designation on an IRA or 401k, and then they later change their mind and try to do it themselves without consulting an attorney, and they create a will saying that they actually want their account to go to this person. They're going to assume because they did the will last that that's going to control. But remember, for the asset to get in probate, it's got to be in your name. So if you've done that, and you see this over and over again, if you had a beneficiary designation, that money's never going to go to probate, which means the will that you did yourself will have no effect on that money.
And a lot of times what we say to the folks is you need to have a plan, not just paperwork. So, someone may have paperwork and they may think it's meeting some objective of theirs, but without legal counsel to determine whether or not that paperwork is going to work for you, you need that attorney. So when people come to us, we're not just giving you paperwork, we're giving you a plan. And then we design the paperwork to meet that plan. And then, like Shane said earlier in one of our other podcasts, that we warranty the plan because we want to make sure that your objectives are made. You could care less what the paperwork says. That's why you come to an attorney. You're not going to draft your own paperwork, but you know what you want. So you come to the attorney will make the paperwork and then that will meet your objectives. And then you have an attorney to advise you along the way, hey, am I still on my plan? Because some people think I just need a will. Well, yeah, you do need a will, but a will in and of itself is not a plan. So the important thing is make sure you have the right paperwork for what you need.
So am I correct in saying that a common mistake would be that people construct all of their wishes, but without that legal documentation, it may not actually be written in a way that's actually enforceable in the end? That's
correct. And if you don't have access to an attorney, as we said, we warn our plans. You've picked the phone up, you have a question, we talk to you. Check our reviews out. If you wonder whether or not we're going to answer the phone, look at our reviews. We talk to our clients even after we do business with them. So absolutely right. That is absolutely right. When you do something yourself and you don't know what you're doing and you don't have access to professional help, then you tend to go down a rabbit hole and it can be destructive.
And I'll just echo one, it's just an example here. A lot of folks come into our practice and they say, hey, I have a trust. Look, I've already got this taken care of. And I'll say, okay, great and wonderful. Well, I pulled it off the internet or whatever. And then I'll say, well, okay, what's in your trust? And they say, well, I don't know. I just have a trust. And I'm saying, well, unless you fund the trust, it's not going to work for you. So there's a lot of things that people don't understand they have to do to make their paperwork and their plan work. So just pulling off, going to wills and trust and pulling down a will or a trust offline, I don't think you get an attorney with it. So, it's important that you have an attorney review your paperwork to make sure that it's all integrated into your plan. You can have paperwork, and if it's not integrated with your assets and all everything that's a part of your life, then that document's not going to accomplish what you need.
That's right.
Yeah, estate planning definitely doesn't seem like an area to skimp out on. As we wrap up, both for Shane and for Kimbro, if you could give us some final takeaways.
Well, the important thing is when you need and you're thinking about an estate plan, basically, we do a 5-step approach at the Jurist Law Group. And the 5th step is get a trusted advisor. Because doing estate planning, if you make a mistake and you think you understand the law, or you've heard some neighbor or some friend of you tell you what to do, most of the time, a lot of those, friendly advices it's really not true or accurate. So unless you have a trusted person that you can depend on to give you the proper guidance, then, you may be messing up big time. So it's very important that you have a plan, not just paperwork, and that you have an attorney to help you through that plan as you go through life. And so an estate planning is a process. It's not an event. And always try to find a trusted estate planner to help you.
Hear, hear.
Hear, hear.
Hear, hear. I like that. Everybody, thanks for tuning in to the Jurist Law Podcast with Kimbro Stevens and Shane Cox. For more information or to connect with our team, visit juristlawgroup.com. Kimbro, Shane, thanks so much for your time today.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.